that our client has not been produced before any court of law. This court at JKA is a forum-shopped court. It is a court that our client will not likely get any justice. The judge has given the following orders. 1, that application is certified as urgent. 2, the applicants to serve the respondent with the application by 3 p.m. today. We confirm that we have served the respondent before 3 p.m. 3, that the respondents to file and serve a response to the application by 9 a.m. Monday, the 12th of May 2025. 4th, that the applicant, that is Aroko, to be produced before the High Court on Monday, the 12th of May 2025 at 10 a.m. for the respondent to show cause why he should not be immediately released on bail or why his continued detention should be sanctioned by this court. Therefore, we expect our client Philip Aroko to be presented to the High Court on Monday at exactly 10 a.m. for the court to release him on bail. As the defense team, we are determined to get justice for both our clients, and as we can see, we have made several attempts. But this court was forum-shopped. This court cannot grant justice to our clients, and the High Court has listened to us. And probably Cliff can add something. And Nyabet.
Ili kungoja kwamba Aroko Philip aweze kuletwa kuwasilishwa mahakamani. Sasa hivi ni saa 8:15 hajaletwa mahakamani, na tumekuwa tukingoja tangu asubuhi kwamba aletwe, lakini hajawasilishwa. Ilitulazimu tuende katika High Court ambapo tumepata orders kwamba ile application yetu iweze kusikizwa, na hakimu Alexander Mteti amepeana maagizo ama orders kwamba tuserve ile application kufikia saa 9 hivi leo, na Aroko apelekwe mahakamani Nairobi Jumatatu saa 4, ndipo koti iweze kuamua kama anaweza achiliwa kwa dhamana ama asiachiliwe. Kumbuka hapa hivi JKA bado tuamungoja, tunasikia ako humuhumu, hatujamuona, lakini na hatujui wachunguzi ama wapelelezi wanataka kufanya nini, sababu hatujaona mpaka saa hizi, hatujaona application yote ambayo imefailiwa. Wanataka siku ngapi, kama wanarudi naye, kama hatujamuona sisi. Na niseme kwamba tumekuwa pale mahakamani Jumatatu iliyopita. Kuna washukiwa ambao waliletwa, ambao waliweza kuwekwa ndani korokoroni kwa muda wa mwezi mmoja, na kesi yao itakuja kutajwa mwezi wa 6. Ile trajectory ambayo koti imepeleka ni kwamba ile application ambayo tuko naye, ile ambayo imefanya tuje hapa hivi leo, ni ya kwamba siku 30 za kufanya kazi, na koti vile ilipeana zile siku 30 wakati huo mwingine, haiwezi enda kinyume na yale ambayo yalikuwa imeenda ama zile siku ambazo ilikuwa imekabidhi wale wachunguzi. So ndio maana tukasema kwamba court itakuwa biased na haitapeana dhamana kwa washukiwa wale ambao wameletwa pale, wala kuwapatia bond, wala kuwapatia siku tofauti na zile 30 ambazo ilikuwa imepeana hapo mwanzo. Kumbuka kwamba hiyo jana tulikuwa mahakamani tena tukipinga kwamba hii koti haina mamlaka in jurisdiction wise kulete ama kusikiza hii kesi. Uamuzi wa leo umedhihirisha kwamba ama koti ilisema kwamba iko na majukumu ama iko na jurisdiction ya kusikiza zile cases ambazo zinakuja pale, hata kama hii offense inasemekana kwamba ilitokea pale Ngong Road. So ni kusema kwamba tumeacha wale wengine ambao wanataka kuendelea na kesi waendelee na hiyo kesi. Sisi baadaye tutakuja kupata ile ruling kwamba kama hakimu anaweza jiondoa katika ile kesi au la. Lakini kwa sasa hivi leo ni kwamba tumeacha wale watatu wakiendelea na kesi. Wengine wale wawili ambao wataki hakimu aendelee na ile kesi watakuja kusikiza uamuzi wa hakimu hiyo Jumatatu. Asante.
The mother has not seen his brother. He's worried whether the brother is dead. We expected his brother to be in court today. What can you tell the country?
I'm only expecting justice for my brother because it's just a political candidate and not a murderer. So I only expect justice to be done. The first is very possible.
Your name,
Doris Petra.
Have you seen your brother? Here. The area member of parliament, the area member of county assembly, the ward where Mheshimiwa Aroko comes from is around.
Mheshimiwa Samu Kumu, close aide to Honorable Philip Aroko. What I can say, I see politics in this game. And today, our member of parliament is being buried. And Honorable Philip Aroko has been denied the opportunity to go and attend that burial. The reason we don't know. And that is why I'm saying there is politics in this. In as much as we want justice, because we also feel justice should be given to the family of the late Charles Ongondowere. But that justice should not be used as a reason to pin down those who are not involved in anything. So what we are requesting, that on Tuesday, the way the lawyers have said, that on Tuesday we want the High Court to... On Monday, we want the High Court to give Philip Aroko an opportunity to do activities that he normally do normally. And lastly, last but not least, where is Philip Aroko? That is the question we are asking ourselves as constituents. Where is Philip Aroko? If they know he's culpable, why can't they produce him to court? Kindly, we are asking the state agencies, can you produce Philip Aroko so that we see him? Because we are not at peace if we don't find him. He's innocent, and the court will prove that. And I'm also requesting the people of Kasipul, justice will be done to them. And Aroko will come back and go back to Kasipul and meet his people. Otherwise, thank you. As we wait for Monday, let us all be patient. Let us acknowledge and let the rule of law take course as we move on towards this case. Thank you so much.
Thank you.
Your Honor, in an application for recusal, the party seeking such a route must establish the usually high standard. It's usually high standard for the basis of such an application. Why is it a high standard? Because it impugns into the integrity of the judicial officer being requested to recuse herself or himself.
And I'll be pausing as I look at the judicial pen so that I know when to continue. Now, why does it impugn the integrity of that judicial officer? The judicial officer takes an oath to dispense justice without fear or favor.
It's like you are here when I demand my ruling and you are not here.
Thank you.
Maybe follow that you.
No, these are principles that are known.
It was not present virtually.
Yes.
These are the things that I said and you are not there.
Yeah. These are principles that are known. These are tenets
Properly, the judicial officer dispense justice properly.
without fear or favor. That is the oath that judicial officers take when they take these jobs. My colleagues here, they are not apply for the job that you are now taking because of this sacred oath. Otherwise, they would have crossed over. Your Honor, an application for a recusal is an objective, and the honors is an objective application, and the honors to establish is an objective, must be an objective application, objective, and the honors of establishing the tests for the recusal is upon the party who is applying for it. Your Honor, in several cases, the courts have formulated the test. And the test is whether a reasonable person would, on correct facts, reasonably apprehend will correct facts that the judicial will reasonably apprehend that the judicial officer will not apply an impartial mind.
And I found the proceedings ongoing, and I was making a submission there.
Your Honor,
And
I think
Your Honor,
decorum in court, and this one I'm talking about, we have to address the court with some dignity. Okay? You cannot attack a judicial officer from the bar without making a formal application, putting an affidavit, indicating the reasons why a judicial officer.
Objection, Your Honor.
I'm still on my feet.
You just will come
You
out.
just-
No, I'm
Objection.
still on my feet.
Objection, Your Honor.
Didn't you find him on his feet?
You know what? I've been a CEO of the Law Society of Kenya.
Your Honor, let's
Under certain behaviors,
It was
That-
failure that removed
that-
you from there. Don't
my
tell me.
This is getting personal and you cannot allow this.
Let nobody
This
talk
is
here.
getting personal.
Let
The
nobody
rule
talk
is senior counsel must be respected.
here.
No, that's personal
It's not
now.
walking in.
No, that is
Yeah.
personal.
It's not walking in.
Yes.
And Your Honor, some of the councils have actually been misconducting themselves by even making certain allegations to the media,
Just a minute.
including yesterday,
Just a minute.
which we shall also bring to the attention of this court.
Just a minute, Council.
Yes.
What I was
Thank
saying
you.
is that, so the record shows now you are coming.
Thank you.
But
Most obliged.
can we deal with what the court has made a ruling on? Even as me, I never made any ruling, I never made any directions, I was just a request. Whether the two parties can be heard, and then also to notify the respondent side that
Decide, can we consolidate, can we not consolidate, can the facts the same and all that. That means you have read it, we have not. And we are supposed to also, even for a moment, be told that this is what we are talking about, this is the application, so that we can also give a contribution. So the prosecution is telling you, no, let us have a different time, we can do it. The court is saying, no, the facts are same. Are we just coming to watch? Isn't that bias? Isn't that
I think, I don't know whether we are seeing things from completely different perspectives.
Completely.
The reason why I mentioned Philip Aroko is because I didn't want to be taken the path of Aroko today, the way I was taken the path of Aroko yesterday, who was not before. So that we can distinguish issues and we deal with issues separately. That was my intention. So that once we get to Aroko, we deal with Aroko. Once we are dealing with these five, we deal with them. So that you not start telling me that Aroko has not been brought 24 hours have lapsed. So that issue, you know, it's not subject of a discussion. The reason I brought the attention is, so anything to do with Aroko, let's not go to that deliberations because the time is due. So the issue of telling me now it's 24 hours have lapsed, it's not been brought, now I make a finding on it. Those are the issues that I didn't want to. So what I'm saying, so can we just give with E081 of 2025, once we are done, then we go through. Because even the other respondents, they really want to tell the court something. And I really want to hear them. I really want to hear Edwin or Joel, Dennis, Sarah, Alan, or what I want to tell them, because I can see also this. Can we deal with E081?
You know what we are requesting?
Yes.
At 157 does not give the DPP power to run this court. We are feeling, our client is feeling that the court is under the control of the state. And that's what we are praying, that we are making an application to you. Let the DPP keep off. Thank you.
The other respondents
Allow us to.
The first respondent, just concentrate on your crime.
The issue,
Leave Aroko out of this, because I think you really want to force Aroko here.
we are not
By
forcing
any
Aroko.
means.
We are not forcing Aroko, Your
Let's
Honor.
just
All
deal
we are
with the
saying,
first respondent, and I don't know the nexus between the first respondent and Aroko. Why don't you just deal with him? Then after that,
We are
once we get to
dealing-
Aroko, we deal with Aroko.
Your Honor, we are dealing with the file that is before you. And the file that is before you has nexus to a file that is, again, going to come before you or any other officer. And that is the issue that we're saying of perceptions. And perceptions are very, very heavy to deal with, so that then the next question we'll ask, or the first respondent is asking, whether this court is going to be impartial in the decision that is going to render after all this has come to bear. And then it being that this is not a court that is run by a sole judicial officer. There is another court. You have two courts here. Even when we are making this application, which has got no feet to stand on, kindly accord us latitude that we go before another judicial officer, that we will feel that is not biased, and ventilate our issues there, where we will be discussing about the issue, whether or not 30 working days should be granted for the first respondent to be held as they do the investigation. Because if again, as you do that examination, cross-examination, and internalize what we are saying, If the court again says there is no element of bias, that bias has, in the perception, in the mind of the first respondent, is there. So however nice the ruling is going to be, or even 10 days, 2 days, 5 days, that will also not sit well with the first respondent. So kindly allow us to go to another judicial officer, we process our issues there. Mr. Beta will add one of the issues.
But what I'm
Your Honor, counsel can also raise in his application for recusal that he feels the court and the DPP are the same. He can raise that as a ground so that we proceed.
No, let's be professional. Let us be professional because we're the professionals here. Myself, DPP and the we are the professionals here. And let's carry ourselves the professionals that we are. And we know the proper thing, and we need to do the proper thing. Can we address the issues of E081 of 2025 in E081 of 2025? We exercise professionalism, all of us, myself included, because we are the professionals. Once we deal with that, the court will make a decision, the other parties will respond, and then we deal with that. Once we go to E082, we will get there. And we deal with the issues of E082. Let's be professional. So kindly, let's, as much as it is so tempting to talk about so many things, let's restrict ourselves to E081. Sometimes we get so excited and want to talk about things. But let's narrow our issues.
Let's proceed.
Let's not get excited over everything else. We deal with one case at a time, so that the court can make decisions on the merits of each individual case. Because remember, at the end of the day, it is individual criminal culpability and responsibility, even if they are filed.
Your Honor,
Yes, let's proceed.
allow me to proceed.
Yes,
The state should know that their removal is at the Public Service Commission. Let us deal with the question here of this court.
Let's just proceed.
Thank you, Your Honor. So it is our considered view.
Delivered on 13th of May at 10 a.m. That's what we make on Tuesday at 10 a.m. The state should proceed and argue its application as a unit plan for and fifth respondents. First and second respondents are at liberty to leave as the application again is done. Fourth and fifth respondents is being argued. So we proceed. So I'll just make ruling because the three are not part of it. We proceed.
Then we'll be leaving. So we'll also be asking that the investigators, meanwhile, because we do not know how the ruling and everything else will go thereafter, should not stop the investigation. Now they have those days and
Jana, before you is an application. Pardon? Yes, we can.